You're creating your masterpiece, but should you register the copyright? And if so, how does the process work? The United States Copyright Office registers over 500,000 copyright claims each year. Under current copyright law, you do not need to register your work to receive copyright protection in the United States. Instead, copyright protection is automatic as soon as an eligible work is created in a fixed and tangible form. But registration gives you several important benefits. First, to enforce your copyright in a U.S. work in court, you will need either a registration certificate or a letter of refusal from the Copyright Office. Second, registration can make it easier for you to prove your legal case. If you register your work before you publish it, or within 5 years after first publication, the facts on the certificate are presumed to be correct. As a result, during a lawsuit, the defendant, or person accused of infringement, carries the burden to prove that particular facts on the certificate are inaccurate. Third, if you register your work before someone infringes your rights, or within 3 months of first publishing the work, you can ask a court to have the infringer pay your attorney's fees. You'll also be able to ask for statutory damages instead of actual damages, which can be difficult to prove in copyright cases. Finally, after registering your work, you can ask U.S. Customs and Border Protection to seize unauthorized imports of infringing copies. Registration also benefits the copyright system and the general public. It creates a public record of claims to ownership and authorship, which can help people contact a copyright owner to seek permission to use a work. So, now that you know how important it is to register your copyright, how do you do it? To register, submit an application to the Copyright Office. The standard application is generally the best option for one work. We strongly encourage filing online at copyright.gov. The online system offers many benefits, including lower filing fees, faster processing, electronic payment, and for some types of works, the option to upload your work. The Copyright Office also offers options for registering some types of works in groups using one application and filing fee. Before the office can examine your application, it must be complete, meaning it must include the correct fee payment as well as the required copy, or in some cases, copies of the work. The application form, filing fee, and other requirements depend on what type of work or works you're trying to register. You can learn more at copyright.gov, where you'll find guidance and tutorials for registering specific works. What happens when your application arrives at the Copyright Office? Once you submit your application, it is assigned to an examiner to determine whether your copyright claim can be registered. If there are questions, the examiner may email you, so keep an eye on your inbox. The examiner first checks for missing information or mistakes, then compares the information on the application to the copy of the work you submitted. Examiners don't normally investigate the factual claims made on the application, such as the identity of the author or the date of creation, unless there are obvious contradictions in the application materials. The examiner may also have questions about information known by the Copyright Office or the general public. The examiner verifies that your work is a type protected under the Copyright Act. Categories include literary works, such as novels, poems, and textbooks, musical works like songs, dramatic works, pantomimes, and choreographic works, photographs, paintings, sculptural works, movies, TV shows, sound recordings, and architectural plans. Copyright does not protect ideas, systems, methods, or discoveries. The examiner also checks that the work is original. This is a critical task. To be original, a work must be both independently created and creative. The law doesn't require a lot of creativity. In fact, most works submitted to the Copyright Office make the grade quite easily. However, not all works are sufficiently original to be protected. For example, single words, names, titles of works, slogans, short phrases, and simple shapes are not protected under copyright. The examiner must also determine whether a submitted work was independently created by the author. The Copyright Office makes this determination based on the materials you submit in the application and information known by the Copyright Office or the general public. It does not do outside research or compare your work to the work of others. A common error is when the submitted work doesn't match information provided in the application, so the examiner looks for any discrepancies. You must indicate in your application if the work contains a substantial amount of material that was created by someone else, or that was previously published or registered. If the examiner decides that the Copyright Office can't register your work, you will receive a letter of refusal. There is a process to ask the office to reconsider its decision. However, the refusal letter is sufficient to be able to bring a lawsuit regarding the work. In most cases, if there are no issues with the application, the examiner approves the application and the office mails you a certificate. Congratulations! You have a registration. To learn more about the copyright registration process, please visit our website,